Section 4. Resolution of investigating prosecutor and its review. If the investigating prosecutor find cause to hold the respondent for trial, he shall prepare the resolution and information he shall certify under oath, and information that he, or as shown by the record, an authorized officer, has personally examined the complainant and his witnesses, that there is committed, and that the accused is probably thereof, that he accused was information of the and of the evidence submitted against him, and that he has given an opportunity to submit controverting evidence. Otherwise, he shall recommended the dismissal of the complaint. Within 5 days from the solution, he shall forward the record of the case to the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy in cases of offenses cognizable by the bayan in the exercise of its original jurisdiction. This on the resolution within 10 days from their receipt thereof, he shall immediately inform the parties of such action. No complaint or information may be filed or dismissed by an investigating prosecutor without the prior written authority or disapproval or approval of the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy. Where the investigating prosecutor commends the dismissal of complaint but his recommendation is disapproved by the provincial or city prosecutor or chief state prosecutor or the ombudsman or his deputy on the ground that a probable cause exists, the latter may be himself file the information against or direct another assistant prosecutor or state prosecutor to do another preliminary investigation. If upon repetition by a proper party under such rule as the Department of Justice may prescribe or motu proprio, the Secretary of Justice reverse or modify the resolution of the provincial or city prosecutor or chief state prosecutor, he shall direct the prosecutor concerned either to file the corresponding information without conducting preliminary investigation or to dismiss or move for dismissal of the complaint or information. With notice of the parties, the same rule shall apply in preliminary investigation conducted by the Office of the Ombudsman. Section 5. Resolution of Investigating Judge and its review. Within 10 days after the preliminary investigation, the investigating judge shall transmit the resolution of the case to the provincial or city prosecutor or to the ombudsman or his deputy in cases cognizable by the bayan exercise of its original jurisdiction. The finding of fact and the law supporting his action, together with the record of the case, which shall include A. The warrant if the arrest is by virtue of a warrant. B. The affidavit and other supporting evidence of the parties. C. Or bail of the accused and the order of his release. D. The transcript of the proceeding during the preliminary investigation. And A. The order of cancellation of his bail bond if the resolution is for the dismissal of the complaint. Within 30 days from receipt of the records, the provincial or city prosecutor or the ombudsman or his deputy has a resolution judge on the existence of probable cause. Their ruling shall expressly and clearly state the fact and the law on which it is based on the parties shall be furnished within copies thereof. They shall order the release of an accused who is detained if no probable cause is found against him. Section 6. When arrest may issue. A. By the regional trial court within 10 days from the filing of the complaint or information. The judge shall personally evaluate the resolution of the prosecutor and its supporting evidence. He may immediately dismiss the case if the evidence on record clearly fail to establish probable cause. If he find probable cause, he shall issue a warrant of arrest or a commitment order if the accused has already been arrested pursuant to a warrant issue, conducted the preliminary investigation, or when the complaint or information was filed pursuant to Section 7 of his rule. In case of the existence of probable cause, the judge may order the prosecutor to present additional evidence within 5 days from notice, and the issue must be resolved by the court within 30 days from the filing of the complaint or information. B. By the municipal trial court when required pursuant to the second paragraph of section of this rule. The preliminary investigation of cases under the original jurisdiction, the Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, or Municipal Circuit Trial Court may be conducted by either the judge or the prosecutor. When conducted by the prosecutor, the procedure of the issuance of a warrant of arrest by the judge shall be governed by the paragraph A of this section. When the investigation is conducted by the judge himself, he shall follow the probable provided in Section 3 of this rule. If his finding the recommendation are affirmed by the provincial or city prosecutor or by the ombudsman or his deputy, and the corresponding information is filed, he shall issue for a warrant of arrest. However, without waiting for the conclusion of the investigation, the judge may issue a warrant of arrest if he finds, after an examination in writing and under oath of the complainant, and his witnesses in the form of searching questions and answer. The probable cause exists and that there is a necessity of placing the respondent under immediately custody in order not to frustrate the ends of justice. C. When warrant of arrest, not necessarily, a warrant of arrest shall not issue the accused is already under detention pursuant to a warrant issued by the municipal trial court in accordance with paragraph B of this section of is the complaint or information was filed pursuant the section 7 of this rule or is for an offense penalized by fine only, the court shall then proceed in the exercise of its original jurisdiction.